What's the difference between a last will and testament and a living trust? A will is merely a wish document. The creator of the will simply designates who they want to receive the assets in their estate. It covers their wishes. A will must be validated by the probate court to determine whether it's legitimate, valid as a legal document. In today's world, the potential for something being fraud is real, so the court has to know that the document is valid and that the person who wrote the will actually did it. Once the court determines the validity of the document, the distribution of the assets will occur as determined by what the will states. If anyone contests the will, the court will hold a hearing to determine what actions to take. It is not uncommon for someone to question a will, especially in a mixed family. Whether the will is contested or not, the process can be stressful and costly. There's legal fees, court costs, and other miscellaneous charges, including appraisals, to determine an asset's true value. It is not uncommon for legal and court costs to range from 5 to 10% of the value of the estate. If you have minor or disabled children, the will can include guardianship directives as to who you want to name as the guardian. Otherwise, the court will have to decide that as well. Different than a will, a revocable living trust is a contract. To conform to the requirements for a document to be a legal contract, the owner, who is referred to as the grantor of the trust, will have 2 witnesses and a notary sign the documents. The witnesses are attesting to the fact that you, in fact, did sign the documents, and the notary makes it official. As the grantor, you will also name an executor and successor trustee, who can be one and the same person or 2 people. A revocable living trust has many benefits beyond what a will does. For example, in addition to who you want to receive a beneficial interest or a bequest, you can also specify when and how you want certain assets distributed. Keep in mind, assets include anything with financial or material value, as well as sentimental value. You don't get these benefits with a will. Unlike a will, having a revocable living trust bypasses the entire probate process. Your estate can be settled quickly without the hassle, stress, cost, and loss of privacy, all of which are associated with the probate court process. Probate court is the government's plan. The estate plan with the revocable living trust is your custom plan.
Hello, my name is Brian Nates, and I am the president and founder of Family Legacy Docs, a will and trust creation package. We are FamilyLegacyDocs.com. It is a platform that we got designed to really help you make it simple, streamlined, and easy when it comes to planning your legacy. Well, quite simply because it matters. So let's not make it overcomplicated. What we did was we have a step-by-step process that literally helps you go through the platform, make sure everything is set up right, get your wills done, get your power of attorneys, your healthcare directives, your trust, setting that all up. Funding the trust is important as well, getting everything inside of it, right? So we created this platform, once again, to make it easy, make it affordable. In the background, it's all attorney drafted documents, okay? And we, once again, want to just keep it simple for you, but yet very customizable to what you need done. And it doesn't have to be the cost of what a lot of firms charge out there. We wanted to solve a problem, make it simple, make it duplicatable, and really serve you well. So take a look at what Family Legacy Docs has to offer. Reach out if you need us. We're here to help. Thank you now.